Welcome, Justice Stevens. On behalf of the National Constitution Center, it's so great to see you. You honored the National Constitution Center a few weeks ago by visiting us. The Constitution Center, as you know, is the only institution in America that has a congressional charter to disseminate information about the Constitution on a nonpartisan basis. And I can't think of a better book to discuss in connection with that mission than your wonderful new book, 6 Amendments, How and Why We Should Change the Constitution. You've proposed 6 constitutional amendments on topics ranging from campaign finance and sovereign immunity and political gerrymandering to gun control and the death penalty and the anti-commandeering principle. All of these are cases where the Supreme Court ruled differently, and you dissented in many of these cases. Tell me why you decided to write the book and why you decided to propose these 6 constitutional amendments.
Well, it's sort of a project that just kind of grew, to tell you the truth. The immediate cause was the killing of the school children in Connecticut, and the New York Times story about the fact that the anti-commandeering rule places an obstacle in the way of the government's getting total information on background checks to precede the purchase of guns. And I had not actually realized before I read that New York Times story that that rule does in fact increase the likelihood that a person will be eligible, will be allowed to purchase guns when he shouldn't have. And that was not a cause of that particular tragedy, but it likely may have been a cause of other similar tragedies.
Well, this anti-commandeering rule, which is your first amendment, and I've dog-eared all of them with these high-tech pieces of paper, sounds technical, but is actually quite important. And I'm going to read the amendment that you propose, and you can help explain it. You say that adding just the 4 words "and other public officials" after the word judges and the supremacy clause would allow Congress to impose mandatory duties on public officials in every state. What does that mean, and what is the problem that you're seeking to remedy?
Well, I think that the supremacy clause, properly construed, would already have allowed the government to impose mandatory duties on state officials, the police, for example. I would have thought they could have requested a local policeman to help to search passengers at an airline terminal or something of that kind. But the court, as you know, decided otherwise in the Prince case. And I think the potential consequences of the decision are more serious than many people realize. But they're not the kind of consequences that arise every day, but they're kind of a time bomb sitting in the back room, as far as I'm concerned, where it may in fact impede action that could be terribly important in a national situation.
The Prince case that you mentioned involved the Gun-Free School Zones Act. It was a federal law that Congress passed to regulate guns in schools. The Supreme Court, as you suggested, struck it down on the grounds that federal officials can't command state officers to carry out certain duties. And you presciently objected and said that there might be a future terrorist attack, and this was before 9/11.
That's right.
And you said that this would make it hard to respond to terrorism and other acts of violence.
That's exactly right. And I really think that the rule in place now would interfere with a draft law, for example, where both in World War II and in other prior situations, the federal government has made important use of state officials to help get the Army drafted. And I do think it's more important than people realize.
You also said that the court misconstrued previous precedents, that before the court had refused to endorse this broad states' rights principle, and in Prince it really changed the law by exalting state sovereignty to a degree that was not justified by history or precedent.
Well, that's true, although it's interesting enough that the majority opinion in Prince did not cite either of the 2 cases that would have been provided better support for its holding than any case they did cite. One of them was a pre-Civil War case that had basically held that there was an anti-commandeering rule, and Justice Marshall, in a later opinion, overruled that case and basically said it was the product of another part of our history that has long gone by. is pre-Civil War and pre-14th Amendment.
You know, this is a big theme that runs throughout the book. In your view, the Civil War and the Reconstruction Amendments that followed it transformed the relation between federal and state power and gave the federal government broad power to protect minorities and to solve national problems. And you object in many of these cases that some of your colleagues on the court were adopting a pre-Civil War vision of state sovereignty that is not justified after the Reconstruction Amendments themselves.
I think that's right, and I really think, although I don't say as much about this in the book as I learned while reading and trying to put it together, I think that the President Grant and some of his immediate successors are not adequately appreciated for the work they did, and I think that there was sort of an underlying campaign among some historians who are partial to the South largely to cast doubt on the capacity of Grant, and I think he's a much better president than people generally assume.
You also think that the Reconstruction Amendments gave much broader powers to Congress than the court is currently recognizing in a range of cases.
I think that's correct.
You have in your discussion of sovereign immunity, that's another topic that sounds technical, but I know you feel very strongly about and has big consequences. It also is a states' rights issue. You're going to be able to explain it, of course, far better than I can. Let me read the amendment that you propose when it comes to sovereign immunity, and you'll tell me why you think it's important. You say that neither the 10th Amendment, the 11th Amendment, nor any other provision of this Constitution shall be construed to provide any state agency, or state officer with an immunity from liability for violating any act of Congress or any provision of this Constitution. Why do you propose that amendment?
Well, it's kind of a long story, and it's really an interesting story because the doctrine that is now in place is, according to the majority holdings, is kind of implicit in the plan of the convention as part of the Constitution. It started out in the Chisholm against Georgia. The question is whether there was a common law immunity to protect Georgia from paying its debts. And the court held by a vote of 4-1 there was no such immunity. And then the 11th Amendment was adopted in response to that decision. And for years, particularly with opinions by John Marshall, the amendment really was construed very narrowly to apply only to cases in which the state itself was asserting a sovereign immunity. And he basically construed it in a way that if relief could be granted against other state officers, the amendment would be no obstacle. And that was basically the state of the law until after the Civil War. And during the period of Reconstruction, the process of reinterpreting the rule began. And particularly in some cases arising out of Louisiana, the court basically, they first held that Louisiana could not welch on an obligation. Then a few years later, after there had been a change in administration and the northern troops had been removed from the South, the court took the opposite view and it decided a case which really is embarrassingly inconsistent with Marshall's early ruling. And I really think that there's a connection between the Reconstruction states' rights attitudes that developed in those years and the doctrine of sovereign immunity, which later on became not only protected from paying their debts, but it developed over the years that it now protects the states from having their agents be required to obey federal law. And the doctrine no longer relies on the 11th Amendment, which didn't fit very well anyway. It moved into the area where it's implicit in the plan of the convention, even though 4 of the 5 people in the Chisholm case didn't understand that. But then it developed to the point where the court required stricter statements of federal intent to impose liability on state officials. The Atascadero hospital case basically announced that rule. And in response to that rule, Congress adopted several statutes expressly requiring the states to obey federal law in intellectual property area for the most part, patent cases, copyright cases, trademark, and so forth. And this was on